from Community Legal Centres Queensland, and today we'll be talking about the upcoming changes to the migration agent regulation in Australia. So we've got Rob from Rails here today with us, but before we get started, I'd like to acknowledge the traditional owners of the land on which we're holding this webinar. In Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and the country, I'd also like to pay my respects to the traditional owners of the land throughout Australia and welcome many First Australians listening in today. So, the Migration Act 1958 regulates the provision of immigration assistance. So unless you're a registered migration agent, you generally can't prepare visa applications or assist with merits review proceedings. The current scheme has been the subject of multiple reviews regarding how dual regulation of legal practitioners providing migration advice can lead to confusion and duplication for both lawyers and for consumers. So in today's presentation, we've got Rob from Rails, the Refugee and Immigration Legal Service, and he's going to discuss some of these upcoming amendments that are taking place in November, which will hopefully allow lawyers to provide migration advice or assistance without being registered with MARA, the Office of Migration Agents Regulation Authority. He'll also talk about some key issues for community legal centre practitioners seeking to assist people with immigration law problems. So today's webinar will be recorded. We'll take questions at the end of the webinar as we generally do. So I will let you know how you can ask questions, and that's by pressing the button that looks like a hand, as you've done this morning to test the sound. We'll see those hands come up and we can unmute you so you can ask your question if you've got a microphone. If you don't have a microphone, the easiest way to ask a question is simply to type your question into the question or chat box on your GoToWebinar control panel in the top right-hand corner of your screen. So I sent out the PowerPoints this morning about half an hour before we began, and they've also been uploaded to the handout section of the GoToWebinar control panel for you. We'll be doing some polls today as well, so make sure you are paying attention and you can pop your answers into the polls when they come up on the screen. That will really help Rob just sort of know who's in the room and also to test your knowledge a little bit at the end as we go through. I think that might be all from me for the moment. So we'll take the questions at the end, but you can feel free to pop those questions into the box at any time. And if you do have any tech issues, the best way to do that would be to simply email those over to me, as we've got Rob in the building today, so we're sharing a computer. So I think that might be all from me for the moment. So I might hand over to Rob to get started. So hopefully I'm just going to set up the microphones there. And I've got a question that's already come through, so I'm just going to double check that. Raquel, can you hear us? We have started and there is sound, so hopefully you can hear. Might just see if we can get the volume up. So I've just got the volume up higher, hopefully you can hear. Okay, great, Raquel, all good. So I'm just going to take those questions away. Okay, fantastic. Let's get started. So I'm just going to hand over to Rob now. Thanks, Rob.
Thanks, Carly. We'll start off with a poll, I guess, no?
So you'll see the poll come up in a second, guys. So if you can just answer the poll that's up on your screen now and just say whether you are currently a migration agent, a lawyer with an unrestricted practicing certificate, a lawyer with a restricted practicing certificate, a lawyer without a practicing certificate, or none of the above. And we'll just have that poll open for another 30 seconds for your responses to come in.
Okay, thanks. Looks like most are lawyers. Right. Thank you for that.
And to close.
Yeah, I think close the poll, yeah.
Do you want to share it?
Oh, yeah.
So hopefully you can see that on your screen now. So you can see that we've got 64% lawyers with unrestricted practicing certificates, 29% lawyers with restricted practicing certificates. We've got 14% who are registered migration agents currently, and 14% who have elected that none of those apply. So I'll just hide that poll now and we'll move on to the next screen.
Okay. All right. The Regulation of Migration Agents Bill will remove lawyers from the regulatory scheme governing migration agents so that lawyers can't register as migration agents and will be entirely regulated by their own professional bodies when giving migration advice. The bill has broad political support and is set to commence on 19th of November, but that's dependent on the government prioritising it in their list of business in the Senate and the Department of Home Affairs having their IT systems in place, and these are by no means certain. The webinar, basically we're going to look at the current law, the history of regulation and the arguments for and against reform. We'll have a look at the bill in detail, the effect of the reforms, where to get some training, and a few key tips in immigration law. And we'll have a couple of polls and questions along the way. Currently, you must be a registered migration agent to give immigration assistance. The Office of the Migration Agent Registration Authority, MARA, regulates the migration profession, including registering migration agents, monitoring compliance and complaints, and taking disciplinary action. To be a migration agent, you must be currently an Australian citizen or permanent resident, or a New Zealander with a special category visa, over 18, proficient in English, a person of integrity, fit and proper, and have sufficient knowledge. And that's shown by completing a prescribed course, which is a 12-month graduate diploma in Australian migration law and practice, which has recently changed from a 6-month certificate course, plus a separate capstone assessment course. Or you show knowledge by having a current legal practicing certificate. You also need to have professional indemnity insurance and do your continuing professional development. Currently, who can give migration advice? Under Section 280 of the Migration Act, a person providing immigration assistance must be a registered migration agent. Immigration assistance is using knowledge or experience in migration procedure to assist a visa or cancellation review applicant or a sponsor with an application or a merits review application or court proceedings or in a ministerial request. Lawyers, without those who aren't migration agents, can give immigration legal assistance without being registered. So that is, they can give advice about court proceedings, or where it's not advice about preparing a visa or merits review application or a sponsorship or ministerial intervention matter. It's a strict liability criminal offence, 60 penalty points. If you charge fees for this and you're not a migration agent, the maximum penalty is 10 years prison. The scheme has resulted in dual regulation of lawyers who register as migration agents to provide the full range of immigration services. Anyone can give administrative assistance. They don't need to be a migration agent. That includes clerical work, preparing an application, translation or interpreting services, advising someone they must apply for a visa, or passing on information provided by a third person without substantial comment or explanation of the information. Anyone can also do clerical work, which is things like typing answers into an application or other administrative tasks without being a registered migration agent. The history of regulation of the migration profession or industry: before 1992, the migration advice in Australia was unregulated. You just informed the Department of Immigration you wanted to be a migration agent. And then 1992 was brought under full government regulation through the Migration Agents Registration Scheme, administered by the Department of Immigration. In 1998, there was statutory self-regulation where the Migration Institute of Australia was appointed as the Migration Agent Registration Authority to be the regulator, and a Migration Agent's Code of Conduct was developed. In 2008, there was the Hodges Report, and self-regulation wasn't supported. The MARA became an office attached to the Department of Immigration. So from being the MARA, it became the OMARA. Some people joked it was the Irish version of MARA. In 2014, there was the Kendall Independent Review of MARA, which recommended an end of dual migration agent regulation. The 2014 review recommended lawyers be removed from the regulatory scheme and not be able to register as migration agents and be entirely regulated by their own professional body. It was said this would reduce burden on practitioners, clients and businesses. Ironically, the reason stated for including lawyers in the regulatory scheme post-92 was to achieve consistent standards of professional conduct and quality of service within the migration agent profession. The 2014 review also said that deregulation would bring Australia in line with similar common law countries. So Canada and the UK and New Zealand have comparable registration schemes for migration agents, and none of these require lawyers to be registered to provide immigration advice or assistance. Though a difference is they have an opt-in system for lawyers, whereas under the proposed law coming here in Australia, there'll be a ban on lawyers being registered. So no opt-in, you have to either be a lawyer or a migration agent. We have another poll. So this is just to check that you're with us. So there's some questions there.
All right, it looks like most people have answered the poll now, so I'll just close that one up, and you can see there that 80% have said that to be able to give immigration assistance, you need to be registered as a migration agent. 30% have said you can give immigration legal assistance. So, Rob, how did they go?
You need to be registered as a migration agent to give immigration assistance. Immigration legal assistance is for lawyers.
So we're just launching the next poll now.
Currently, lawyers. Yeah. Okay.
All right, so I think we've got about half of you have voted, so maybe another 10 or 15 seconds to finalise those votes. All right, I'm just going to close the poll now for you. And you can see we've got equal results for this poll around the question, lawyers who are not registered migration agents can give A, immigration assistance, or B, immigration legal assistance, or C, administrative assistance. And we've got half-half for B and C there. I'm just going to hide those results now.
Well, they're both correct.
Okay, we'll keep going.
Okay, so both correct. So good. Sounds like you're listening. You have to excuse, I've got a little bit of a cold, so please bear with me. So why end dual regulation? So there were quite a few submissions relating to this, and there's submissions also put into a Legal and Constitutional Affairs Legislation Committee report in October last year. The Law Council of Australia raised several arguments. They said lawyers are already subject to one of the most stringent professional regulatory regimes in Australia and practice in a range of complex areas without the need for dual regulation in these areas. It also says it's confusing that the Act prohibits lawyers from providing legal advice about a visa or review application before a tribunal, but permits them giving that same advice when identical issues arise in court proceedings with immigration legal assistance. Solicitors have a duty to provide comprehensive legal advice to their clients which addresses all relevant legal issues. For example, if a non-agent lawyer gives family advice to a client with a visa issue, the client won't be able to obtain the comprehensive strategic advice they require unless the lawyer is a registered migration agent. For example, RAILS, Refugee and Immigration Legal Service, who I work for, and Legal Aid Queensland have a clinic for migration domestic violence cases where Legal Aid does the family law advice and RAILS does the migration advice. So needing to have two professionals there. Another example is an in-house solicitor explaining an employment contract to a foreign employee who's sponsored by the company to live and work in Australia. So there's a mix of immigration, employment and contract law issues there. The Law Council of Australia also said it was an untenable restriction on the practice of lawyers because by virtue of their admission, lawyers are recognised as qualified to practice, interpret and apply the law. Assisting clients to prepare documents that comply with prescribed legal regulations is a legal task which no practicing lawyer should be restricted from providing, said the Law Council. They also said that law practitioners must pay extra fees, both practicing certificate and migration agent registration fees. There's also confusion for consumers as to who to go to for migration advice and any redress is, if any redress is required if there's a complaint. Do you go to the MARA, Migration Agent Registration Authority, or to your law society? And legal practitioners are subject to up to 3 complaints handling processes, which would be the MARA possibly, the law society possibly, Office of Fair Trading if there was some issues there. There's an additional CPD brings an extra financial and time burden. Although this has changed recently because MARA are accepting a current practicing certificate, legal practicing certificate as evidence of required CPD. There may be issues with that, but at the moment that's the way that stands. So the Refugee Council of Australia, they welcomed the change. They said that the changes would allow more legal practitioners to provide legal advice for refugees and asylum seekers who often rely on pro bono legal advice. The Law Council also agreed with that the changes would open the pool up to more experienced practitioners to do pro bono work. They also said changes would help in judicial review in federal court. So a barrister doesn't need to be registered for judicial review, but a client may, for example, require a visa to stay in Australia while the case is ongoing. This needs immigration assistance by a registered agent, so an instructing solicitor would need to be a registered agent. The Law Council said changes will help community legal centres to adequately brief lawyers and provide comprehensive legal services to migrants. But there are some concerns about whether or not we should go ahead with the ending of dual regulation. The Migration Institute of Australia said could lead to a lack of expertise, as lawyers may not have the knowledge of migration law and policy, as they wouldn't have done the 12-month graduate diploma required for non-lawyer registered migration agents. And also the changes contradict the recent strengthening of entry requirements for migration agents, which have increased the 6-month grad certificate to the 12-month diploma. There's also a proposed compulsory placement and restricted 2-year practicing period proposed. And the changes would allow any lawyer with a practicing certificate with no formal training or experience in immigration law to be able to provide immigration assistance. Lawyers who have no previous immigration law experience, not studied migration law, with no commitment to the migration profession will be able to offer ad hoc migration advice to consumers, said the MIA. And there'd be confusion for clients, consumer protection complaints to 2 bodies, and professional indemnity insurance. Insurers would need to reassess the risk and be assured that the lawyer was competent in giving immigration assistance. Currently that assurance is there, said the MIA, by virtue of registration as a migration agent. There were concerns about a loss of legal expertise. Some large migration practices aren't legal practices but employ lawyers as migration agents and often do pro bono or government-funded services. With the changes, legal practitioners will only be able to work in connection with a legal practice, and the lawyers in these migration practices may leave these migration practices because if they stay, they'll have to have their registration cancelled if they don't want to keep their practice. If they want to keep their practice certificate, there was a loud concern expressed about current sole practitioner migration agents with restricted practicing certificates who could lose business as they need to be supervised to get unrestricted certificates so they can set up a legal practice in order to continue giving migration advice under the new regime. They would have to find a law firm willing to take them and their clients to fulfil the supervision requirements of the restricted practicing certificate while continuing to practice immigration advice. One submitter said that this would mean handing over her clients to law firms and hoping the law firm would employ me and not dismiss me shortly after. So in response to these concerns, the Senate committee looking at the bill recommended that the government consider implementing a formal transition period of 2 years for this group. So the registered migration agents who hold a restricted practicing certificate are able to meet the requirements to obtain unrestricted practicing certificates while running their current businesses. There was also a constitutional issue raised by one of the submitters that the new law would infringe the implied constitutional guarantee of freedom of communication on all political matters. The argument, only know partial of it, is that deregistering migration agents who become Australian legal practitioners restricts a class of communications, including communications made to the Minister, by those previously registered migration agents who can no longer provide unsupervised immigration assistance outside the legal practice in which they are employed. Previous clients may also be left without advice and assistance from their former agent in this regard. The opinion stated that the bill would be less open to challenge if it permitted Australian legal practitioners, or at least those who hold a restricted practicing certificate, the option of continuing to be registered as migration agents. Under the proposed law, you won't be able to be both a practicing lawyer and a registered migration agent. So from that review back in 2014, that lawyers be removed from the scheme, the bill, the Migration Amendment Regulation of Migration Agents Bill 2017 was put before Parliament. The passage of the bill, June 2017, it was introduced into Parliament. On the 10th of August, the Senate referred the bill for inquiry and report by 16 October 2017. 27 March 2018, government amendments were introduced to allow the MARA registration to continue 2 years to allow a restricted practicing certificate holder obtain an unrestricted practicing certificate. 28th of March, the bill as amended passed in the House of Representatives. It's currently awaiting debate by the Senate. It's subject to parliamentary timetable. The proposed date for removal of legal practitioners with unrestricted practicing certificates from the OMARA regulatory scheme is 19th of November 2018. In the meantime, Australian legal practitioners need to continue to register with the OMARA in order to provide immigration assistance. And that's pretty crucial. The MIA, Migration Institute of Australia, recently sent out a notice saying that it wasn't clear whether the Senate will further debate the bill in the 7 sitting weeks left in this year, which could impact the timeframes for the Home Affairs IT system changes required to allow lawyers to be removed from the MARA system. And it appears that some lawyers may be letting their registration lapse, migration agent registration lapse, in anticipation of the changes being introduced. And the MIA recommended that lawyers reconsider that because there's a possible delay in your ability to practice in the migration field. That's a watch this space. And So what we'll look at now, we'll get into a little bit more detail about what the amendments will actually say. The key changes, legal practitioners with unrestricted Australian legal practicing certificates will have no restriction on providing immigration advice so long as it's done in connection with a legal practice, and they'll be regulated solely by their applicable legal professional body. The Australian legal practitioners with unrestricted legal practicing certificates will no longer be eligible to be listed on the MARA Register of Migration Agents and will no longer have a migration agent's registration number. This is regardless of whether a legal practitioner runs their migration business separate to their practice. Holders of unrestricted legal practicing certificates will not be able to register with the OMARA. Those lawyers who hold a law degree, holders of restricted legal practicing certificates have a transitional period of 2 years with another 2 years possible extension to allow their MARA registration to continue to obtain an unrestricted practicing certificate. And lawyers who hold a law degree but no practicing certificate or are admitted as lawyers and don't have a practicing certificate will still be able to renew their registration with OMARA and won't be impacted at that stage by these changes. So it's a significant impact. At the moment, there's around 7,300 registered migration agents, around 33% to 2,400 were Australian legal practitioners, and 92% commercial and 8% non-commercial. So let's have a look at some of the new provisions in the Act. So in new definitions under Section 275, Australian legal practitioner, this is intended to capture only those lawyers who hold an Australian restricted or unrestricted practicing certificate and excludes those lawyers who are admitted but do not hold a practicing certificate. Also for New Zealand lawyers, because under the Trans-Tasman Mutual Recognition Act, they're eligible to practice. If they're eligible to practice in New Zealand, they're entitled to be registered as an Australian legal practitioner, so they won't have to register as migration agents to give immigration assistance. Legal practice is provision of legal service regulated by a state or territory. A restricted practicing certificate is one requiring supervised legal practice for a specified period. And the restricted legal practitioner is, as it's seen there, one whose practicing certificate is restricted. So who can give immigration assistance? The new Section 283, subsection 3, ensures that an Australian legal practitioner can give immigration assistance without being required to register as a migration agent, as long as the giving of immigration assistance is in connection with legal practice. So that's admitted that part of subsection 3 and replaced that with the Australian legal practitioner from giving immigration assistance in connection with legal practice. New 281, there's a penalty of 10 years prison for a non-registered migration agent asking for or receiving a fee or reward for giving immigration assistance. The changes here means that this doesn't apply for immigration assistance given by an Australian legal practitioner in connection with legal practice. The key sections 289B and 278A provide that an applicant must not be registered with MARA if they're an unrestricted Australian legal practitioner. If they have a restricted practicing certificate, they can't be registered unless they are eligible. And they're eligible for 2 years after they first held a restricted practicing certificate. And you can apply to MARA once for an extension of up to 2 years. And you can ask the AAT to review that MARA decision if they don't allow you that extension. So as I mentioned, that 2+ 2 year period was introduced as part of the amendments in March last year, because otherwise current migration agents on restricted practicing certificates who had established migration businesses, not legal practices, may have been forced to close their businesses because lawyers can't provide legal advice as sole practitioners until they completed a required period of supervision under a principal with an unrestricted certificate and have a legal practice. So the requirements, say for a principal solicitor, sole practitioner requirements, say in Queensland, a person who wishes to practice as a principal of a firm or sole practitioner, they must have an unrestricted certificate and complete other training in practice management with the regulatory body, which is Queensland Law Society here, to become a principal of a firm or a sole practitioner. And there's the QLS practice management course, a 3-day face-to-face course to develop the essential managerial skills and expert knowledge to manage a legal practice. And of course, you need professional indemnity insurance. There is, under the Legal Profession Act, a provision to reduce that. So for those lawyers who have practiced as migration agents for a long time without getting an unrestricted practicing certificate, the Law Society may exempt a person from the supervised legal practice requirement, or may reduce the period having regard to the length and nature of any legal practice previously engaged in by the person or their supervisors. So that's a possibility, but I haven't asked the Law Society whether that would happen, but that is in the regulation, in the Act. So back to the changes coming if the bill passes. So amended 302A requires MARA to cancel registered migration agents registration if they become an unrestricted legal practitioner, or if they're restricted, but is or is no longer an eligible restricted legal practitioner. So you have to be an eligible practitioner. It's almost like a dating site or something. News 312 should be 4 and 5. Migration agent must notify MARA in writing within 28 days after they become a restricted or unrestricted legal practitioner. This is to determine if they're an eligible restricted legal practitioner, or if they're not eligible, whether their registration must be cancelled under 302A. The penalty is 100 penalty points, which is consistent with current provisions where a migration agent has to notify MARA within 14 days after other issues might arise for them, such as changes in employment or bankruptcy or conviction. Lawyers who cease to be registered migration agents on 18th of November 2018 or after the transition period, and those cancelled under 302A for becoming an unrestricted practitioner or a restricted practitioner who's not or no longer eligible, become inactive migration agents under the new provisions. This means that MARA then has the power to require the person for 2 years while they remain an inactive migration agent to produce documents that are owned by or were produced by their clients. This is to provide consumer protection, particularly where the agent operator is a sole trader and no suitable person is appointed to take over the business. So just going over that again, just to make it clear the effect of changes. Unrestricted legal practicing certificates, not eligible to be listed on MARA Register of Migration Agents, nor have a MARN, that's the Migration Agent Registration Number, nor be able to register with MARA. No restriction on providing immigration advice and regulated solely by a legal professional body. Restricted legal practicing certificates, transitional period to allow MARA registration to continue for 2 years and possibly 2 more years to obtain an unrestricted certificate. No practicing certificate. Lawyers with law degrees or who are admitted but have no practicing certificates, they can still apply for or renew MARA registration, but they would have to fulfil the knowledge requirements, and the knowledge requirements are a practicing certificate. So sort of a catch-22, you have to get a practicing certificate, but then you then would have to go within a legal practice to be able to practice. Or if you did the grad diploma, then you could be a registered migration agent. We have another poll, I think.
All right, so we've actually got a series of 3 polls. So I'll just launch the first one for you, and you can pop your answers in when it comes up on your screen. So we've got some responses coming through, but make sure you pop your answers in. So we've got almost half have voted now, so we'll just give you another 10 or so seconds to complete that response. All right, so I'll close that poll now and share those responses with you. So, Rob, how did they go?
How did they go? Yes, so the answers are for a registered migration agent holding a restricted practicing certificate immediately before November 28th, 19th of November, their registration will cease either after the transition period, so it's 19th of November 2020 or 2022, or once they become an unrestricted legal practitioner.
Fantastic. I think everyone did pretty well there. So let's launch the next poll. So it's just a true or false answer there. So we've got some responses coming in, but make sure you pop those in for us. Another 15 or so seconds to put your response in. All right, I'll just close that one up now. So again, how did they go, Rob? So the question there?
Yes, wonderful, 100% accurate. You're all doing very well.
All right, so I'll just...
However many the all is.
So I'll just pop the last poll up there for you now. So this question is whether you agree with the proposed changes to the legislation. So you can answer yes or no. All right, so I think most people had a pretty strong and clear view for that one, so I'll just close that up. And it's been 100% yes. So I'll just close all those polls up now and we'll keep going.
Okay, so the next couple of slides are just basically going over the stuff that we went through before and that you've just done with the poll, so I won't really go through these. But it gives a little bit of a diagrammatic view of what you can do, presuming the changes go through on 19th of November 2018. That date, of course, could change because that's the proposed date. You've got a practicing certificate, and I won't go through all that stuff again. So there's actually been another inquiry into migration agents. So it's a fairly vibrant area. So March 2018, the government announced the efficacy of current regulation of Australian migration agents inquiry to look at particularly registration and regulation of migration agents, including education, English proficiency, fees and fraud. So there were there's 2 more public hearings left to go. They're in tomorrow and on 19th of September. There's written submissions are closed, and there's 2 anonymous online questionnaires for migration agents and clients, and they're still ongoing. So just in terms of that, some of the submissions just in relation to migration agents. Spoke about there being some unscrupulous and incompetent agents, that there should be an increase in the English level score for new migration agents. Currently, it depends on the level of schooling you go to, done in English in certain countries, or if you go through a IELTS, which is the International English Language Testing System, and you have to get a score of around 7 on average, and that is asking for that to be higher, and also asking for a period of supervised practice for new agent. The Law Council of Australia initially suggested that registered migration agents should be banned from all administrative appeals tribunal work, but the council changed that submission, or added a supplementary submission saying what in fact they wanted to put forward was that there should be no AAT general division work for registered migration agents. That's around some of the citizenship and cancellation matters where the department has lawyers in, and it's a more adversarial system, whereas most of the tribunal work, as the merits review the migration agents do, is more the inquisitorial form of review. There's submissions calling for more funding for humanitarian cases, so people are not forced into unscrupulous or incompetent agents. More power on MARA to recover funds. They can only do regulatory things like cancel and suspend. And then also submissions saying that complaints about migration agents may also come from my clients because they're victims of the complexity of migration process, or of the Department of Home Affairs' poor decision making and lack of communication, rather than a problem with the agents, and also of clients' poor prospects at the start. So that was an interesting submission. There are broader issues, but there was the Department of Home Affairs. I just might go back on that one. The Department of Home Affairs also put in a submission, and they acknowledge that there are corrupt migration agents, both registered and unregistered. However, they make up the minority. They said such corrupt migration agents potentially operate in company structures that may maintain a broader culture of corruption and misconduct. This may include operating as unscrupulous labour hire intermediaries, and even facilitating visa fraud and foreign work exploitation. And the department also mentioned that education agents are providing immigration assistance unlawfully, and registered migration agents find it difficult to compete in this market. So there were a couple of other parts of the submission of the department regarding migration agents, and there are a lot more other submissions. That's only a very brief swipe of all of those. So there are other broader issues in the migration space. I don't know whether you've heard out there, but there will be a new Minister for Home Affairs, because the current Minister, Peter Dutton, has resigned from the front bench today. And so this reform that we're looking at is part of an ongoing broader turbulence in the migration area. So it's highly political. The department has become a much more enforcement-focused body, taking much more adversarial report. There's move to shrink migration numbers. That's part of a broader population policy debate. There's continual changes in visa requirements. There's been an inquiry, or there's going to be a move towards simplifying the visa system, cutting down the number of visas. That's commenced. There's been cutting of funding for legal services for asylum seeker boat arrivals, and serious tightening of funding for onshore protection visas and other vulnerable applicants. increased scrutiny in citizenship matters, alongside a government push for stricter citizenship requirements. That's leading to a backlog of at one stage around 200,000 citizenship applications. It would be need to note that citizenship is not covered by the Migration Act. It's under the Citizenship Act, so the migration agent registration issues don't apply there. Okay, so so I was just going to look at a few migration law tips. Just very quickly do a scan of just a few things, and then we can ask some questions and wrap up. So this is a very quick scan, and it by no means means you'll be able to give migration advice after this. And I'm not suggesting that at all. So migration law is covered by the Migration Act, the regulations, by case law, there's ministerial directions, there's gazette notices, there's procedure advice manuals and ministerial series instructions, which are policy and not legally binding. That's the department's interpretation of the law as guidance for their officers. The structure of the Act is as noted on the screen there, with the control of non-citizens, migration agents, offences, review of protection visa decisions, fast-track review, that's for boat arrivals. They've been given this new process, which is not as rigorous as the ordinary process. Judicial review, restrictions on court proceedings, cost orders, reports include people in detention, civil penalties, investigative powers. The migration regulations are ones you deal with regularly, and part two, the visas, is obviously part of that. And then the schedules are very important as well. So the schedules, so the Schedule 1 is class of visa. So when you apply for a visa, you apply for a class of visa, and within the class there's subclasses which are outlined in Schedule 2. So the other schedules look at if someone's an unlawful non-citizen and want to apply for a visa, and certain bridging visa holders, public interest, health and character requirements involved in there, a special return if you've been refused or cancelled before, conditions on your visa, Schedule 8, and then there's a whole other list of schedules around a whole lot of different visas. So it's very, very complex. The pathway to a visa generally is under the Act that the Minister can grant a non-citizen a visa. It can be temporary or permanent. The classes of visas can be prescribed in Schedule 1 and 2. So you must apply for a class of visa, and then there's the Section 46 Reg 207, what makes a valid visa application, and there's bars on what are valid applications. So it could be for an unauthorised maritime arrival, the Minister must lift the bar before you can actually make an application. If you've been previously refused or cancelled a visa, you'll need ministerial approval. If you've come from safe third countries, these things are important. This is a slide that was given by the Griffith University, who run the graduate diploma on migration law and practice. So it just looks at that Section 46 validity requirements, then the Schedule 1. If the visa applicant doesn't meet the validity requirements, the department won't even consider the eligibility requirements in Schedule 2. So an example of, say, an offshore, a fiancé visa, you apply for a subclass 300, and then you get a onshore temporary partner visa, and then 2 years afterwards you get a permanent visa. If the relationship breaks down during that time for domestic violence, family violence, there are provisions within the Act that can help a person get permanent residence even though they haven't done that 2 years period. So there's migration regulations. If you look at numbers of visas, this list here is a good just checklist for what type of visa. Is it a temporary or permanent, onshore or offshore visitor? So there's all those numbers of visas. As I said, there's a move to restrict those numbers, simplify it all. And then the standard visa subclass criteria in Schedule 2 is time of application and time of decision criteria, when the visa is in effect, conditions and ways of giving evidence. Australia's migration program, permanent, just very quickly there's a refugee and humanitarian program, the family migration program, and the skilled migration program. So there's courses for learning about migration law, the graduate diploma in Australian migration law and practice. There's the Migration Institute of Australia does an immigration essentials for lawyers, a 3-day course. Migration agents have to complete 10 CPD points for re-registration, and in the first year of practice have to complete the Practice Ready program. Each year at least 1 CPD point on ethics. Refugee Immigration Legal Services, AMARA approved CPD, and we provide monthly CPD workshops. LegendCom is an essential online database that you'll need to purchase if you were going to be serious about getting into migration law issues. And for highly experienced lawyers, you can get accredited specialist recognition through your lawyers regulatory body. Also, a very important area of learning is communities of practice. Marion Dickey, who's doing a doctorate on professional studies, was also a very experienced teacher, educator, migration agent, saying parts of these important bits are a shared space, a bounded space, so it's a limited membership, which includes professional boundary. Trust is the most important factor in these, often online communities of practice. So the trust relies on the bounded space and the professional commitment to keep the personal aspects of discussions within the community and to maintain it. And, the sort of no question is stupid, to allow you to be able to really explore things. The ability to participate on different levels, to be a beginner on one aspect of a discussion, an expert on another, and a lurker within the group as well. And the inclusion of the subject matter experts who are willing to share and learn along with the rest of the group. So a wrap up, lawyers with practicing certificates will no longer have to be registered as migration agents, give migration advice. Lawyers with practicing certificates will be taken off and excluded from the MARA registration of agents from 19th of November if the bill passes Senate in time, or later if the bill continues. Some eligible lawyers with restricted practicing certificates will have 2 or plus another 2 years to remain registered in order to get unrestricted practicing certificates to be able to set up a legal practice. You may not get through the Senate in time for 19th November. Migration law is a very complex, highly political area with turbulent change, and there are good courses and training available. So happy to take any questions. Yes, okay, just a little bit more. So this is RAILS, Refugee and Immigration Legal Service. So we're the only legal centre in Queensland specialising in refugee and immigration law. We do a lot of refugee protection, refugee family reunion, family violence ministerials. We've got metropolitan regional phone advice, evening advice service in Brisbane, outreach clinics around Brisbane. We do family law clinics, and we do CPD and community education programs and resources, and all found on our website.
Okay, thanks so much, Rob. That was a really quick run through of what sounds like a very complicated area and some complicated changes, but hopefully mostly positive for particularly the community legal sector and the clients that we assist. So we've got maybe 5 minutes for questions. So if you have any questions, please make sure you type those into the question box just on your GoToWebinar control panel now, so that we can read those out for everyone to hear, and then Rob can take those questions and provide some responses to you. So just while you're popping those in to the question box there, I thought I'd also let you know that there is immigration law training taking place as a masterclass on the Monday prior to the NACLAC conference, which is next Monday, the 27th of August. That's down in Sydney. So that's a full day of migration training, which covers a range of different areas of law. So if you are already down in Sydney, or if you're hoping to come down to the conference, it might be a great opportunity for you to register if you'd like to sort of start providing some advice or have a refresher around migration law. So it doesn't look like there's any questions coming through. If you do want to ask some questions but want to have a bit more of a think about it before you send those over, you can send them by email to me or to Rob. I'm sure he'd be happy to take some questions from you, or you can contact Rails. You can also visit the Rails website, and there might be some good information on there as well. Okay, looks like one question's come in, so I'll just read that one out for you. That's just from Alex. So Alex has said she's interested in your view, Rob, on the in connection with legal practice aspect of the amendments. So if a lawyer wishes to volunteer at a specialist immigration CLC, such as Rails, do you think that would be covered?
Yes, if Rails would be a legal practice, a CLC would be, and so if you've got a practicing certificate, then you would be able to give migration advice, whereas now you couldn't, if that's your question.
Thanks, Alex, for that one. Hopefully that's answered your question. So I might just finish up there. We're right on 12 o'clock. So thank you so much on behalf of everyone listening in today, Rob, for coming over and presenting that great presentation to us. We'll pop that presentation recording up on our website shortly, so hopefully by this afternoon or tomorrow, and send that link out to everyone who's registered today. Please also take the time when you get that email from us to provide your feedback and fill out the surveys through the link in the email. And also remember to register for our upcoming webinars. We've got another one on Thursday. Thanks everyone for your attention and for participating in the polls today. And thanks again to Rob for presenting with us.